Hopefully everybody made it over here safe. I'm your girl Sweet Pea, and we are going to be watching our closing arguments by the defense in the George Pino trial. So if you're just coming over from the Folio 4 sentencing, welcome in. Have a seat. I hope you hit the like, and we are about the like button, and we are about to go in here. Let's see.
Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Rachel with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Pea's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Pea's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Pea's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial. Take it to trial. Let's go. Oh, let's go.
Okay, so hopefully everybody is in here, had a seat, cool, ready. Let's go into the defense. We about to get this to the jury and see if the millionaire is going to be a felon there. I don't know. Is he not about to be a felon? Oh gosh. Georgie Porgy, you made the girls cry. Say it ain't so. Don't do Georgie that way. Oh man. He cannot. He cannot, right? We cannot let Georgie go down like that, right? Say it ain't so. All right. Well, let's go ahead and get into this.
So she's coming down. Everyone, you can see it. Thank you. All right. Ladies and gentlemen, we are ready to proceed. Defense, with the case.
Thank you. Good afternoon. If you have trouble hearing me, please let me know. I heard the prosecutor say to you, theory. What I heard the prosecutor say to you is that in the moments leading up to the crash, with about 9 seconds to go, that George Pino was inattentive. He might have been looking over to his wife while she was trying to text a beautiful video of the girls who had a beautiful day over at the sandbar. He might have been looking at his GPS. He might have been looking over to his right or to his left, that he was inattentive. Those are her words. And if that is true, if that's the state's theory, George Pino, your job is very simple. George Pino is not guilty of a crime. He may have committed human error. He may well have been inattentive. He may not have looked up in time to see the marker to which the revolver alighted. But that does not make him a criminal. We have highlighted for you the law. After all, that's where we are. We're in a criminal courtroom of the United States of America, where if your government, my government, wants to brand somebody a criminal, they have to prove he's committed a crime. Not that he was negligent, not that he has civil liability. Footnote, all civil liability has been resolved already, long before you were sworn in as judge. This is not a civil case. This is not about whether, by a preponderance of the evidence, the state or I should say, the injured passengers have established liability, civil liability. That has already been resolved. We are here today because our government wants Mr. Pino to be branded a criminal for having, by their own statement to you, been inattentive. Now let's look at what the law is, because we are, after all, in a court of law. And what we've done is we've taken what we understand the judge's instructions of law to be before you on the screen. May not be so easy to read because of the distance. There are two crimes that are being charged: vessel homicide and manslaughter. Each of them require that the state prove beyond a reasonable doubt certain facts. And there they are before you. That George Pino operated a vessel in a reckless manner, likely to cause death or great bodily harm to another person. His reckless operation caused or contributed to the death of Lucy. What does it mean to be reckless? Different than perhaps negligent. Reckless operation of a vessel requires the state to prove more than a failure to use ordinary care. And so even if you were to find that the operator of a motor vessel failed to use ordinary care by not looking up and seeing the marker in the few seconds before it alighted, that would be, even under the state's own theory, negligence, if that's what the state has proven. Because to prove it to be a crime, it has to be so willful or wanton. A willful or wanton disregard for the safety of persons or property. Intentional, knowing, and purposeful. Purposeful. A conscious and intentional indifference to consequences, with the knowledge that damage is likely to be done. It's not enough that a human being has failed to do everything he could or she could at a moment in time. This crime requires a purposeful act of indifference, a purposeful and reckless indifference to his passengers. If we look to the manslaughter charge, it specifically tells you it has to be an act that's not merely negligent. It's right there in the law. An intent to commit an act that was not merely negligent. We turn to the next page. Culpable negligence. So you've got recklessness as one principle of law that the state is trying to apply against George Pino. They've also tried to apply this principle of culpable negligence. Sounds like negligence, but it's negligence plus a whole lot more. It's more than a failure to use ordinary care towards others. It must be gross and flagrant. Think of those words in your daily life, gross and flagrant. Like in the NBA, just came to me. People commit fouls, NBA, National Basketball Association. There are fouls, and then there are flagrant fouls. You know a flagrant foul when you see it. Flagrant. It's not that when the basketball player is going to the hoop and his arm gets hit by another player, even if by accident. That may be a foul. But it's only flagrant when it gets to the point that it's so intentional, so diabolical. And even then, referees have to go back to the screen to see just how flagrant it was. If we're going to put a man, we're going to label a man a criminal, it's got to be flagrant and gross, with an utter disregard for the safety of others. And that when George Pino, thank you, Ed, that when George Pino that morning woke up, when he decided he was going to host a group of friends of his daughter, that somewhere along the line that day, his brain somehow shifted into this gross and flagrant world. That he made conscious decisions, because that's what the law requires before we call him a criminal. And I'm sorry I'm getting a bit agitated. It's an emotional day, because we recognize that there was a lot of hurt that came of this event, a whole lot of hurt, a whole lot of pain. Pain that endures till today and will endure beyond today. So we have to acknowledge that, because we all feel it. And I'm sure you felt it as the prosecutor over and again played videos of the injuries and drama and chaos that ensued from the crash. Heartbreaking. Seeing a young girl that we now know wouldn't survive that event. Having to see CPR and medical examiner photos. But the law says that we don't judge these events based on sympathy, because we all have sympathy for those that were injured, those that passed away, those whose injuries will continue on beyond today. But we don't judge someone in a criminal courtroom under these statutes based upon the injuries and the fatality to turn what would ordinarily be just an accident into a criminal homicide. I heard the prosecutor try to give you an example, and I thought it was telling. She said, oh, if someone ran a stop sign and they had a fender bender, that would be just negligence. I think that's what she said. But if that same car, same driver, ran the stop sign, but instead of a fender bender, a mother with a stroller was walking in the crosswalk and got hit and severely injured or worse, would that change the character of the manner in which the person who was driving the car operated that vehicle? The level of injury, the death that might ensue under those circumstances, does not then define the level of recklessness, the level of culpable negligence that we all are here to evaluate. And so with that framework, and with a further instruction that the burden of proof is on the state, if the government, your government, my government, intends to seek a criminal conviction The government, the state must prove its case, not guess someone guilty, not speculate someone guilty, but prove that someone has committed a crime. And that's why the judge told you that we begin, each of us, as a citizen of this great country, citizen of the great state of Florida, we all start with the presumption of innocence. And that presumption carries with all of us whenever we are accused of something in a criminal courtroom until proven guilty. And the burden is proof beyond a reasonable doubt. It's the highest burden we impose upon our courts and our juries. You weigh all the evidence, but if there's not an abiding conviction of guilt, or if it is one which is not stable, but one which wavers and vacillates, then the charge is not proven beyond a reasonable doubt. And the law requires, as part of your oath, to return a not guilty verdict. That is the law. That's why we are here. And so, in evaluating the evidence, I'd like to first begin with just a few fact points that the prosecution has talked about. The prosecutor said to you she hasn't charged Mr. Pino with voting under the influence, so she doesn't understand why, I think she said, we have made such a big deal about Mr. Pino not being impaired. I ask you to recall the opening statement of the prosecutor when you first heard from her. And she said to you that Mr. Pino had 2 beers, and she did this little signal with her fingers as if it really wasn't 2 beers. And she said it to you again today, that maybe he had more. Maybe he had more. That is not evidence. A lawyer's assertion is not evidence. A prosecutor's assertion is not evidence. Just because she wants to argue it doesn't make it evidence. We had to bring out the evidence because the state was suggesting to you that it was more than 2 beers. That's why we are talking about it now, because the state is talking about it. And what was the evidence about beer consumption on that day by Mr. Pino? And we'll talk in a moment about the consumption of alcohol by the passengers and other people at the sandbar that day. Is there any evidence before you, even one witness, that has said to you that George Pino appeared impaired, buzzed, in some way compromised? Is there even one witness of all the people that were at the sandbar that day, of all the people that testified at this trial? Not a single person has said that George Pino was in any way impaired by alcohol. That should end it. We shouldn't have to talk about alcohol, but we have to because the prosecutor keeps insinuating that maybe there was more than 2 beers. Of course, the number of beers isn't the issue, since there's no evidence of it. It's the fact that Mr. Pino's consumption of 2 beers did not result in impairment. And you heard it from Lieutenant Thompson. He told Mr. Pino that it's perfectly acceptable over the course of the hours that Mr. Pino was there to have consumed 2 beers over several hours that afternoon. It's on tape. Lieutenant Thompson told that to Mr. Pino. Mr. Shapiro questioned Mr. Thompson, Lieutenant Thompson, who confirmed it's true. You do not break the law by consuming a couple of beers over the course of several hours and then operate a motor vessel. And you know that other adults that afternoon also consumed alcohol and operated a motor vessel, to include Lucy's dad. And no one other than the prosecutor is suggesting anything about the consumption of alcohol having affected the ability of any of the adults that afternoon to operate their motor vessel. That should end it. But it doesn't with this prosecutor. She continues to insinuate that you should find what's not proven. And certainly you can't find that beyond a reasonable doubt. Later, I'll go witness by witness to show you that this is not coming from me. I took notes of every witness's testimony on this and other subjects, and we'll talk about them. So that's the issue of impairment of alcohol. Let's talk about safety and speed. The prosecutor is emphasizing that Mr. Pino's motor vessel was traveling that day as fast as 47 miles per hour. Every single witness who testified that was on the boat, and I'm going to go through it one by one, felt the speed was safe. They'd been on his boat before. It felt no different. Nothing unusual about the way Mr. Pino was operating his vessel. He wasn't drag racing. He wasn't doing donuts in the water. He isn't like one of those jet skiers that's trying to jump weights and do all sorts of thrill-seeking activities. He was not, contrary to what the prosecutor said to you today, he was not trying to be the cool dad. I don't know where that came from. The cool dad. That Mr. Pino, according to the prosecutor, was in some great rush to get back to Ocean Reef because the party that he had planned for his daughter was going to start at 9 o'clock. It was then 6:37 when the accident happened, 2.5 hours to go until party time. As if to suggest Mr. Pino, in his mind, was worried that the girls wouldn't be ready on time and that he was then going to throw caution to the wind and drive the boat in a way that he had never driven before, because you've heard nothing. No evidence that Mr. Pino has ever had an issue with driving his motor vessel. And many of the passengers have been on Mr. Pino's boat before. That motor vessel, Robalo, is built to handle that speed. Actually, it's built to handle more speed. You may recall that boat had two 300 horsepower engines. That boat is rated to have two 350 horsepower engines. That boat is built to handle an additional 100 horsepower of speed. He equipped it with motors that would provide less speed than the motorboat is equipped to handle. The passengers were seated exactly where the manufacturer of that boat designates passengers to sit. Every passenger's butt was on a cushion. None of the passengers were standing. None of the passengers were sitting on the gunnel. You by now know what the gunnel is. That's the surface at the front. And to suggest that Mr. Pino, could we put the reckless homicide vessel? To suggest that he was being flagrant. Next thing, I think is better for me. No, sorry. There you go. Perfect. That he was being gross and flagrant and disregarding their safety by having the passengers sit exactly where a company that's been in business for decades. I think this Lieutenant Albert said they've been bought out by some huge conglomerate. You didn't hear 1 ounce of evidence that Robalo had notified his operators that there should be no passengers seated in the designated seating. You did not see a label on the boat saying, "Do not sit here." I mean, we live in a society where every package has a warning on it. You buy a pack of cigarettes, it says, "Warning, if you continue to smoke these, it may cause cancer." You go to McDonald's and it has to caution you that they have hot coffee in a hot coffee cup. We give warnings to people for any possible liability. You come home from the dry cleaners with your shirt on a hanger, you take the plastic bag off, and if you read the bag, it says, "Careful, don't put it over your head. You could suffocate if you wrap a plastic bag around your head." We are a society that is so litigious that we warn everybody of any possible misuse of a product. And yet, you did not hear 1 ounce of evidence, not a witness, not even Lieutenant Albert tell you that Robalo has suggested to any of its operators over the last 40 or 50 years that the boat is not equipped to have passengers seated in the designated passenger seats. And yet the prosecutor is suggesting to you he's driving the boat in a reckless manner or in a gross and flagrant manner by having passengers sit where they are designated to sit. I mean, that's just not fair. That's not fair to the operator of the motor vessel. Just not fair. Let's talk about the speed. How many witnesses testified that the speed at which those witnesses were traveling, some of them law enforcement officers, others just ordinary boaters like David Rodriguez, whose boat can achieve 80 miles per hour, that he was doing 50 to 55 miles an hour that day? There was nothing about the speed at which the Robalo was traveling that was at all excessive, gross, or flagrant. And let's say what we all know to be the absolute truth here. If George had not hit the piling, nothing bad would have happened. The conditions were ideal. The waters were calm. It was not a windy day. It was not raining. It was no lightning. There was no oncoming boat traffic. It was wide open bay. The speed had nothing to do with the injuries. What caused the injuries was the crash. Of course, the faster you go, the more likely someone's going to get hurt. Of course, if he bumps it at 1 mile an hour, nobody gets hurt. But the speed in and of itself did not create the danger. Hitting the marker was the problem. So we all understand that, I hope. No one on the boat asked George Pino to slow down. No one said, hey, I'm scared, we're going too fast. Not Mr. Pino's wife, not his daughter, and not any of the other passengers. And with the speed at which Mr. Pino was traveling, even at 47 miles per hour, the state's theory is that with 9 seconds to go, Mr. Pino was on a course that would take it into the marker. And as you may recall, when I examined some of the witnesses, with 9 seconds to go, there's plenty of time to simply turn the wheel slightly and avoid the marker, if George Pino had seen it as he was approaching the marker. Of course, if the state's theory was, he was, for those 6 or 7 seconds, inattentive, that would explain why he hit the marker. He had plenty of time to do it, that is, to change course. But because of inattentiveness, according to the prosecutors, he didn't change course in time. Not reckless, conscious, flagrant disregard. This Robalo boat is yacht certified. That means that it's built to take that many passengers. There is no weight limitation. This idea that 1,000 pounds of passengers is going to create a dangerous situation. No one has said that Robalo warned George Pino or any of its other operators of the state's theory that they're advancing to you in this courtroom. So we dealt for the moment with the alcohol used by Mr. Pino. I'm talking to you now about the speed at which he was traveling and the way he was driving. And so I want to ask you to imagine on that day, if there was a drone watching Mr. Pino's operation of the vessel from Ocean Reef to Billy's Point to the sandbar and back. If any of us was watching, would someone have said, that boat traveling, that way it's traveling, that guy's driving like a lunatic? Because that's what this crime is basically suggesting. Because you know a reckless driver when you see it. It's the lunatic on I-95 cutting through cars, going 30, 40 miles over the speed limit. You know the reckless driver when you see that person. George Pino his boat was traveling on straight lines at speeds that Robalo is designed to travel at, in a zone where there is no speed limit. No posted speed limit, not then, in 2020, 2022, and not today. if it was so inherently dangerous to travel at speeds in the 40s, you have to ask why there is no speed limit posted there. You heard Lieutenant Albert when I questioned him. There are speed limits all through Biscayne Bay. On Miami Beach, on the Lloyd Channel, I spoke to him about that. Posted speed limits like you see on the street. And yet, this channel, Cutter Bay, had no speed limit in 2022 and none today. It's not fair, it's not right to tell George Pino after the fact that there should be a speed limit there. I'd like to talk to you now about the government's emphasis about George's imperfect, inaccurate, unreliable memory of the crash. After the crash, and we'll talk more about George's efforts to help people after he regained consciousness, but for now, it's undisputed that as a result of the crash, the collision, George Pino lost consciousness. He was laying on the floor of the boat, unconscious. Witnesses thought he was dead, bleeding from his head. 4 of his front teeth. Maybe help me find it. What do you have there? The prosecutor said no big deal because the impact only shaved off part of his teeth. That we might have a better argument, I think the prosecutor was suggesting, if you lost the teeth completely. So George Pino, by all accounts, unconscious on the floor of the boat. He hit his face on the floor of the boat and then the back of his head hit the boat. He had 2 places of impact. He was knocked unconscious. We asked a doctor to come testify because the state did not produce a medical witness on the issue of George's injury. We brought you the only medical testimony about that, Dr. Barrett. And before we get into the substance of her testimony, let's talk about the cross-examination of Dr. Barrett to attack her because she charges for her time. This is someone who's been a professor at medical school. She's been a doctor for decades. Her credentials are unimpeachable. And yet the prosecutor is focusing on how much money she charges for her time, that she charges for all her patients. The prosecutor was making something of her preference not to have to process insurance for her patients. They're able to seek reimbursement from the insurance company, but she doesn't do that. She accepts direct payment, and then if they want to be reimbursed from their insurance company, that's okay. As if to suggest you shouldn't consider her testimony because she doesn't accept insurance and because she doesn't work for free. Now, I never asked Lieutenant Albert how much he was charging the state for his time. He's also a paid witness. Because I wasn't going to go there as if to suggest to you that a man who for decades has been a law enforcement officer would lie to you for money. And I think that's what the prosecutor is suggesting that Dr. Barrett did. That's frightening. Because that's what she's suggesting to you. That because she doesn't accept insurance and because she charges for her time, after all, someone had to pay so she could go to undergrad and medical school and residency. Those of you who have family members that have become doctors and specialists, it takes a decade to get to the point where you can be someone of her level. And rather than bring you a rebuttal witness, they brought you no one. They attacked the doctor for telling you what is black and white law of medicine, the principles of medicine. Medicine, she explained to all of us, makes a diagnosis of a traumatic brain injury focus on what happened at the time of impact and in the 72 hours after, not 3 years later. And Dr. Barrett explained to you that because George was seen unconscious by multiple witnesses, and because it was obvious that he had amnesia because he was recalling inaccurately so many of the details of the crash, the diagnosis was beyond dispute. The man was unconscious. He suffered a traumatic brain injury. Now, the word traumatic, I think, is a word that is giving the prosecutor some concern because it sounds traumatic. It should be like he needed to go to a hospital and stay there for a month. But that's not how concussions work, and the doctor explained it to you. And so the questions of a lawyer who worked for the state, not for free, by the way, who is attacking a doctor, a professor, the questions of the lawyer are not evidence. The suppositions of a lawyer are not evidence. The evidence comes from the witness stand. And the only evidence that was presented to you about the issue of George's memory came from an accomplished doctor, one who's a professor, one who has published, albeit she doesn't accept insurance. And she explained to you that George Pino, having suffered a concussion, diagnosed with a traumatic brain injury, unable to accurately recall events related to the crash, including, for example, which boat he was on. He thought he was on the boat that had the 225 horsepower engines that he had previously. He thought he had hit the left side of the boat, he thought the left side of his boat had hit the marker when it was the right side. He recalled to Lieutenant Thompson that it was Nazi he had pulled out from under the boat when we know it was someone else, it was Lucy. All of those mistakes made it clear that George Pino was suffering from a TBI, a concussion, and that his memory would not be reliable. It doesn't mean he had total amnesia. The prosecutor was suggesting to you that he should remember nothing to convince you that he's had amnesia and what they call in the medical world confabulation, filling in details about the event from past memories or other memories. And so when George Pino was recounting what he remembered from the crash, and he thought he remembered that there was a wave that came from another boat, that was his memory of it. It may not be reliable, but there are two things that hold true. First, the science establishes that those are the kinds of failed memories and inaccurate memories and false memories that happen after a concussion. And second, it doesn't tell us, and we don't rely upon it, and you don't have to rely upon it in deciding what actually did cause the accident. Was there another boat with a wave? You can disregard it altogether. And you may recall Mr. Shapiro, when he was questioning Lieutenant Thompson, confirmed that no one else saw a boat out there that day coming back from that marker area immediately after the crash. And so we assumed there was no other boat for purposes of deciding, and for you to decide, whether George Pino acted recklessly or conscious disregard for safety. And because there was no other boat, and because the conditions were ideal, the state really has no theory of why George should be labeled a criminal. Because it's not like George was going and racing through incoming traffic, going zigzagging out of boats, and then hit the marker. It was a perfectly, as everyone said, it was like the ideal day to go boating. And it comes back to what I told you earlier when we started. That what the state is telling you is that George made a mistake. He didn't see the marker. And now we're going to talk about what's left of the case, in a criminal case, where the state has no theory other than to bring to your attention things that they try to influence your decision based on facts that have nothing to do with the operation of the motor vessel. Let's start with underage drinking. And it was a subject of our jury selection when we talked about this early on. Whether the girls, the passengers, were 17 or 27, the age makes no difference. We're not here to judge these parents based on their decision to allow 17-year-old high school seniors to drink. None of them were operating the boat. All of them were seated where they're supposed to sit. There was a life preserver for each and every one available. True, none of them was wearing one, but the law doesn't require it. George complied with the law by having a life preserver available for every single passenger on that boat. Nothing more was required. And what the state is saying is to you is that every time someone comes on your boat and has drinks, and I don't know if it's limited by age, but now the operator of the motor vessel needs to put a life preserver on every drinking passenger. Now, I assume that doesn't apply on big cruise ships, which are famous for people going drinking, or big yachts, maybe. I don't know where the line is going to be drawn in the future. But beware if you're a boater. Beware. Because you take a group of people out on your boat, and they have a few drinks. Some prosecutor will say that because you didn't put a life preserver on that passenger, you are now a reckless boating operator. Because that's what she's saying. But she focuses on the age again, I think, to just sort of to do two things. It's really, of course, much more painful to know that a young person passed. And let me point out that I think the medical examiner told us that there was no evidence that Lucy had any blood alcohol in her system when they tested her. So I don't think there was any evidence that Lucy was drinking. I don't think there was any evidence about that at all. Some of the other girls were for sure. But nothing about Lucy drinking. But it sounds to me like what the prosecutor wants you to do is say he's a bad parent because he, and by the way, the other parents at the sandbar, to include Lucy's parents, are bad parents. And so let's convict them of being irresponsible parents and call them reckless and callous. The underage or any age drinking of the passengers had nothing to do with why the boat hit the marker. I hope that's clear by now. Nor did the absence of a kill switch. Those of you that may not have been on a boat before, we try to explain it. It's this like string that you attach to a button on the console so that if the pilot, the operator, is dislodged or falls into the water, it automatically stops the engines. And the prosecutor wanted you to know that there's no evidence that George had a kill switch. Not required by law. Would not have changed the outcome here. But the prosecutor wanted you to know that, and that the flares that were on the boat were expired. Even though I brought out through Lieutenant Alder, even expired flares can serve the function, although it doesn't comply literally with the regulations. And of course, flares had nothing to do with this case, and having unexpired flares wouldn't have changed the outcome here. All right. So now I'd like to spend some time talking about the witnesses. That's the evidence, the people you heard from. So that you have no doubt that when I share something with you, I am doing my very best to rely on the evidence and not on my theory or my argument. I rather rely, and I want you to please rely, as is your oath, on the evidence. And I sequence them differently than when, in the order that you heard them, to try to do it in a more organized fashion. I'm not particularly famous for being organized, but I've tried my best so that we can cover the subject together in a meaningful way. Everything starts at Ocean Reef. That's the place where the Pinos were celebrating their daughter's 18th birthday. And in addition to the virtual mass and the pickleball tournament that George organized and the boat ride that he had organized, there was going to be an event that night at 9 o'clock, dinner, the end of the night. After, I guess, the Florida State game, it was the Florida State game that was being played that evening. And George Pino organized the dinner to start at 9, and it was going to go until 11. But we heard from a witness named Araceli Alvarez, she was the event planner at Ocean Reef, that they could show up late and stay late because there was no other event afterward. And I thought that that's important because the prosecutor's theory is that George became reckless, he became indifferent to people's safety because he wanted to make sure the girls were Instagram ready in time for this party. That's their theory. He was worried about them being Instagram ready. And that he'd be willing to risk the lives of these girls so that they could shower on time. Then we have the testimony of the people that attended the sandbar and the events of today. It included Lucy's dad, Andres. And here's what he testified to as part of the state's presentation, including the answers to the questions that were asked on cross-examination. He was not concerned that George Pino had consumed too much alcohol. He himself had consumed alcohol. He felt he was able to operate his motor vessel. He did operate his motor vessel. He drove his motor vessel the exact same place that George Pino would drive his motor vessel. He allowed his daughter to drink. It was part of the so-called culture. He knew Ceci Pino almost his entire life. There was a loving relationship between these families. He was at the sandbar until at least 5:41 p.m., and we know it's 5:41 p.m. because there's a photograph of the Fernandez. I think it's going to say, I don't remember the mark of the boat, but it's a 20-footer more or less. And you recall Mr. Fernandez is floating in the boat, in the water behind the boat, and that was timestamped 5:41 p.m. And you know that George Pino left at 6:18 p.m. from the sandbar. So up until 5:41 p.m., at least, sometime after, the Fernandez boat leaves the area. Mr. Fernandez had not remembered until we examined him the other day that actually he was planning to attend the sandbar, had changed his mind. We know that because we produced the text message where he told George, for sure I'll be at the sandbar. But then he changed his mind. That's fine. And he did come out. And you heard nothing to suggest that any of the adults at the sandbar thought that there were too many passengers on George Pino's boat. This is really important in my view, because the state's theory is too many people sitting on that boat to be safe. The same passengers that landed at the sandbar from Ocean Reef, the 14 people on board, were the same 14 people that went back. So if it was not reckless and not flagrant and not consciously indifferent to have 14 people in that boat coming to the sandbar, the same should hold true going back to the Ocean Reef. And if any of the adults or the parents at the sandbar thought there was something unsafe about these underage girls who've been drinking going back on Pino's boat where they came from, they could say so. Not 1 ounce of evidence that George Pino was told by any of the adults there that day that, hey, George, too many people on your boat, or anything of the sort. Four passengers testified. Cami Alvarez, Carolina Monterrey, Claudia Portocarrero, and Natalia Reed. Cami Alvarez testified that after the collision, she thought Pino was dead. On the way to Billy's Point, she felt safe and comfortable. There was no unsafe driving by Mr. Pino. She had no reason to believe he was impaired. No sense of danger, excessive speed, or risk on the return trip before the crash. Here's the quote I wrote down. When Mr. Pino was driving his boat back from Billy's Point, did you feel that he was driving in a dangerous way? Answer, no. She did not notice any perceptible change in speed, and she remembered that George made sure that everybody was seated, what you would expect a prudent operator to do. The prosecutor will use that against George by saying, George, because you told everybody to sit down, you knew you were going to do something dangerous. So imagine that argument from our government. By doing something prudent, by having everyone sit down as is proper, it's, in the state's view, she testified that for a split second, she saw Pino lying between the console with his eyes closed, blood on his head, and thought he was dead. She also said that she and Holly Reed, Nazi, had never been confused for any of the other girls like Lucy. And that was important because George inaccurately thought initially that he had pulled Nazi from under the boat. So those 4 passengers testified. Of course, the state will emphasize that some of the girls themselves were intoxicated. And can we put on the screen exhibit T like Tango? Thank you. If the state had another witness to contradict the 4 passengers on the boat, they could call any one of the witnesses on the list that was provided as Exhibit T. We had Mrs. Pino do a count of individuals in the sandbar. By her count, 13 girls, 8 boys, 15 adults, for 36 total. Full page. The state did not call any witness from the sandbar to contradict the evidence that I just discussed with you. Now, Cecilia Pino, the mom, no one is suggesting that she is suicidal or homicidal. She was concerned about her own safety and that of her daughter, little Ceci and the girls who she's known since most of them were born, there's no suggestion that she would get on a boat with someone who was intoxicated, driving at lunatic speeds, and subject herself, her daughter, and these girls who she loved to danger. Because if you find that George was doing this, you're basically saying so too was Ceci Pino. That the mother of little Ceci, the camp mom, for lack of a better word, that she too was, quote, reckless in allowing her husband to operate the vessel. It's the only inference you can draw. What else would you say? And not at one moment in time did Cecilia Pino, the mom, say, hey, George, slow down. She didn't feel there was any danger. None of the passengers said, hey, George, slow down. That's the unrebutted testimony. If you need a break, I can take a break. 36 people at the sandbar, 15 of them adults, sharing an afternoon and sharing alcohol. The state put before you the picture of all the empties, the empty bottles. So the Pinos serve as basically the garbage can for that afternoon. That boat becomes one huge garbage can. And everybody puts all the garbage on their boat. And no good deed goes unpunished, because now the state parades before you all of the model. And so, being responsible citizens is now evidence against them. Mrs. Pino she told you, I brought it up right at the beginning. She felt totally comfortable motoring along. Can we put up A28? Oh, sorry, V Victor. This is a picture timestamped at about 6:31 p.m. Just full screen first. There you go, that's good. So, hoping everyone can see, this is a picture from the stern, that's the word we use in boating, the rear of the boat. That's George Pino with the hat, white hat, and Ceci, his wife, sitting next to him. You can actually see the sun catching the right side of his face, and he's staring into the sunset, so to speak, although it's about an hour and a half before sunset. And of course, the state is critical of questions that are asked by the defense about the sun and the tides and all of the circumstances. But of course, the reason why all of these questions are asked is to get the evidence out to you so you can evaluate the facts. And so, for example, if it was 8 in the morning, the sun would be to the east on his left. And so it might be very important in understanding how the sun creates glare off of the water surface in deciding what visibility someone might have late in the afternoon. The state brought you no evidence, no discussion, no analysis of that. Okay. But what you have is George Pino on this boat, and all of you had an opportunity to see the boat in person. George Pino is not 6 foot 8 inches tall like Paul Alvarez, whose head would be a foot above George Pino. And you can get a sense, because some of you stood on the boat, and you can see that the boat, when it's on plane, and I'm doing a profile, the boat's bow comes up. On plane means the boat has already accelerated, over the hump, so to speak, and is now riding on a plane. That's what they call it. And so, this is the windshield. So the 47 mile per hour that the prosecutor was talking about the wind. There's a windshield. For that reason exactly. It's not like a motorcycle, which has, some of them have no windshield. This one has a windshield. And on this boat, if we can put a sea chart. There's the bow seating that we talked about. This one doesn't have cushions on it right now, because this is after the fact. But this is where the passengers were seated. And you already heard the testimony that their torsos and their heads would protrude above this gunnel, the freeboard of the boat. And those of you that saw it probably took note that that boat, when it's floating in the water, that bow of the boat, you can decide for yourself. You all saw it. You can decide for yourself. How high is it above the water line when it's floating? And the operator, who's a foot shorter than Lieutenant Albert, what is he looking at as he looks to the front? Certainly he's going to see the passengers that are sitting there who are facing him. We'll talk about that more in a moment. Ceci Pino, in the picture I just asked Mr. Armolino to show you, she's actually in the process of sending a text or using her phone. Now, let's understand the rules of the road, because the navigation rules have been presented to you. There's no requirement that a boat operator have a separate person serve as a lookout. You're not the lookout rule. I can drive my boat all by myself, provided that I'm looking where I'm going and I'm serving as the lookout for my boat. Just want to be sure there's no confusion here. I asked the witness very clear. The operator can be the lookout. You can have more than one lookout if you like, for sure. And then you'll hear in a moment, or you'll see it when we talk about it, the operator's head is on a swivel. Because when one's operating a boat on the open bay, there are no traffic signals, there are no yellow lines and white lines, there are these markers from time to time, but for the most part, it's just open bay and potentially boat traffic. And so, no different than driving a car, you need to look where you're going. I remember that from when I was a kid. My dad would say, hey, son, look where you're going. And if you don't look where you're going because you're inattentive, you might fall. If you don't look where you're going because you're distracted, you might trip. Or, as might be the case according to the state, if you don't look where you're going at some point in time, you might hit something. That's what we call a crash, an accident. And if that's what happened here, it's not a crime. The judge will instruct you about those navigation rules. I'm good. Thank you. In the state of Florida, the law requires operators of vessels upon its waters to follow the navigation rules. However, a violation of these rules, individually or cumulatively, is not sufficient by itself to constitute culpable negligence or recklessness. Even if an operator violates one rule, or even multiple rules, individually or cumulatively, that is not enough in and of itself to establish recklessness or negligence. It's back to whether you're driving a car or driving a boat. If you fail to see the stop sign, it could even be a stop sign that you've passed 100 times. You're not paying attention that day. You're going to work and you're thinking about something else. You fail to stop at the stop sign and something awful happens. And that's what we call an accident. And like when you're driving to work every day, when you get into a routine, just draw on your own life experience. Each of you has life experience to bring to the courthouse. You've driven this path 100 times. Sometimes you leave your house, you get to work, and you don't remember passing half the places that you know are on the way. You just never noticed them. You were just daydreaming. Who knows what you're thinking about? Or, my wife will forgive me for saying this, she runs over that same pothole every time. That she should know by now, there's a pothole down the street, don't run over the pothole. It doesn't make people criminals for being human and overlooking those things, particularly when your brain is on autopilot, not real autopilot like a boat, but you're just coming along doing your routine. And if all the state proves to you is that George Pino was on his way back to Ocean Reef, as he always was, and he overlooked marker 15 and he hit it, he'll be held accountable in civil court as he was, but that doesn't make him a criminal. Mrs. Pino, to finish her testimony, corroborated what every other witness testified. Her husband suffered a head injury, fractured teeth, stitched elbow, a leg gash. It's beyond dispute. But what the state does to try to, again, avoid dealing with the lack of a theory of criminality, instead it's focusing on that the Pinos, several months after the accident, with George suffering from the post-traumatic stress, you heard he's on psychiatric medications, they go on a family trip to the Panhandle, and for maybe the first time in 4 months, he breaks out a smile with his daughters. And I think what they're saying to you is that should convince you that George's lacked sympathy because he was smiling and one of his daughters posted the picture. That you should find him guilty because he had the nerve to smile for a photograph with his daughters. The first smile he might have mustered in many months and maybe very few since. And perhaps in the most awkward moment of the trial, knowing that Mrs. Pino had spent much of her motherhood with her daughter and her daughter's friends, including Lucy, she's confronted with a photograph of Lucy by the prosecutor, saying, "That's not your daughter, is it?" Why would somebody do that? Why would that question be asked? Mrs. Pino explained to you she didn't see the accident, and that's why when she was in that civil case having to explain what she knew, she had to rely on her husband's memory, which we know from the science may not be reliable, but that's all she knew about the cause of the accident. You heard from several good Samaritans: Hillary Candela, Hamlet Rodriguez, and David Rodriguez. These were boaters who came upon the scene. Hillary Candela, a gentleman, he did know George Pino by coincidence. He remembers seeing George looking dazed and in shock. That when Hillary Candela screamed out to George to look under the boat, the first time George didn't seem to register the instruction. Second time he did, and George Pino went under the boat and brought Lucy back from underneath. Hamlet Rodriguez was the person to whom George Pino handed off Lucy so she could get to a boat. Hamlet Rodriguez, a former water polo player, did everything he could to help her. He said he was swallowing water against a strong current until someone pulled him out. He left the scene around 7:05, Hamlet Rodriguez, which happens to coincide with David Rodriguez, unrelated to Hamlet, who had been cruising at 50 to 55 miles per hour, sped up to 70 miles per hour to get to the scene. Yes, of course, he sped up because it was an emergency situation, but he said it felt perfectly safe to travel at those speeds. He saw a mature woman bleeding who said a girl was missing. Likely Lucy Pino, since that was the only adult passenger on the boat that he saw bleeding. And I think she told me she was hospitalized after that night. Mr. Pino, by then, was apparently hanging on to the capsized boat after he had passed Lucy off to Hamlet Rodriguez. David Rodriguez described Pino very in shock, crying, but did comprehend instructions. Pino kept asking David, "Are all the girls okay?" Pino would not get out of the water until he was assured that every girl was out of the water. That was 7:04 p.m., I believe, was the timestamp on that. He was asked to look at his camera, what time did you photograph George Pino still in the water? 7:04. The accident occurred, according to the GPS, at 6:37 p.m. 25 minutes, if my math is not wrong, that George Pino stayed with that boat until everybody was out of the water. And to get out of the water, George Pino had to negotiate a swim platform with a tie bar that David Rodriguez explained was no easy task. And David Rodriguez took the unusual step to put his face in George Pino's face. To see if George Pino smelled like alcohol, had bloodshot eyes, slurred his speech, and David Rodriguez, who was curious, maybe even suspicious, I think he said, was satisfied that George Pino was not under the influence of alcohol, that alcohol was not impairing George Pino. And we're talking now 20 minutes after the election. Maybe 25 to be more precise. Then the first responders came to the scene. You heard about Officer Bruto, now retired. He was the first officer on the scene. He saw George Pino get out under his own power. No stumbling. Even Bruto was concerned about a concussion. He said, safety first. George had a head injury. But still, George Pino was able to keep his balance on a narrow 6-inch gunwale. No signs of impairment, said Bruto. Speech not slurred, no balance problem. I mean, you talk about taking a sobriety test. That is probably the most difficult sobriety test anyone could take. Bruno himself traveled at near top speed at 52 to 54 miles per hour in emergency mode. Quote, here was the question: the conditions allowed you to travel safely at nearly 54 or 52 to 54 miles per hour. In other words, the top speed that your vessel is capable of. Correct? Answer: correct. So you have an opinion from a law enforcement officer that the speed is safe to travel. First responder Peter Delgado, a sergeant with the Miami-Dade Sheriff's Office. He triaged Mr. Pino, meaning he rendered first aid. He confirmed, of course, that no life-saving devices, personal flotation devices are required to be worn. The Pino vessel had the required PFDs, none are required to be worn. He's the officer who began talking to us about those markers, the staggered markers in Cutter Bank, and how staggering the markers, as I think you'll see in a few minutes, is less simple, let's say it that way, when the markers are staggered versus red, green, or depending on the side you're looking from. He could see that Pino was an injured passenger, bleeding from his head, and he told Pino do not go to sleep because he was concerned that Pino had a concussion, and going to sleep could be dangerous for someone with a concussion. He too observed no signs of impairment. And no other officer on the scene reported to Delgado or to any other person who's testified in the trial any signs of impairment. John Dalton with the Miami-Dade Sheriff's Office, he transported the girls from the accident scene to Elliott Key. He testified, and this is the best quote I have about speed, quote, no more than 40, 45, maybe at max, because they were panic-stricken and begged him not to drive fast, and it was getting dark. As an officer, saying 40 to 45 is not fast. The opposite of not fast, maybe slow, but it's certainly, it's safe. Let's call it that. That's what the officer called it. The girls on Dalton's boat were sitting, I believe they were sitting, yes, seated on the floor and console at the bow, the front of the boat. By then it was nighttime, doing in the 40s at night. Question, and you felt in those conditions that was a safe speed for you to travel? Answer, yes, sir. He's the one who talked about keeping your head on a swivel, that the operator of the boat has to keep his head on a swivel. And what that means is as someone's operating a boat, since there's no traffic lights, no stop signs, no yield signs, no turn signals, which means that if a boat is coming behind you faster, right, that boat could come up behind you, and so while you're operating a boat, you got to take a look from time to time. You got to swivel, look at your instruments, look at your passengers, and if it takes you more than 6 or 7 seconds to do all of that in one swivel, you might just hit the marker. Lieutenant Thompson testified. He's the witness to whom George Pino candidly said, hey, I had 2 beers. And it was Thompson who explained to them that's okay. It's not illegal to drink and operate a boat. Those were the words of Thompson. Quote, it's not illegal to drink a beer or a couple of beers and drive. And that's a true statement, isn't it? Answer, yes, sir. Now, Lieutenant Thompson was the responder who took the recorded statement from Mr. Pino that you all have seen. Of course, you can judge for yourself in terms of Mr. Pino's speech, whether he appeared to be impaired. A concussed brain, and let's be sure we distinguish between concussion and intoxicated. A concussed brain can fail to record memories. So you can have a concussion, according to Dr. Barrett, your brain is not recording memories, but then when you finally come out of the concussion, you can achieve this score of 15 in the Glasgow scale. So you've got your wits about you, but your memory's not restored. But when George Pino was recounting what his memory was to Lieutenant Thompson, which is recorded, George Pino did not accurately recall the details of the crash. I went through those with you already. And you'll see, if you decide to look at the videos, that The first responders had to wrap George's head in a gauze. And I heard the prosecutor said only 7 staples. Is there a number of staples after which you're convinced that someone's had a concussion? 7 staples on a man's head with the teeth getting bashed in, loose chipping teeth? That's not enough, according to our prosecutor. And so Lieutenant Thompson, together with the help of some other CSI, crime scene type people, did a recreation. But the boat used for the recreation was Thompson's boat, which doesn't have bow seating, which doesn't have the higher gun. And according to Lieutenant Albert, only tracked the last 9 seconds of Mr. Pino's voyage. That was what they were trying to replicate, of course, with the exception of hitting the marker. And that within the last second or so, there's that buoy, and then Lieutenant Thompson avoids hitting the marker. What it proves to you is that if someone is attentive, someone's paying attention, even at that speed, with that lighting, in those conditions, the marker can be avoided. If the operator is inattentive for some reason, is looking at his instrument, swiveling his head, in the time I've just said that, 8 seconds have gone by, he'll hit the marker. Now, we had a little back and forth. It's not going to be a huge point, but I thought it was important again to bring the facts to you. It was high tide when this accident happened. High tide. Thompson thought high tide was at 4:44 in the afternoon. He was wrong by 2 hours. Lieutenant Albert thought, according to his report, it was at 10:30 at night. So the two of them were completely at odds with each other in terms of what they thought high tide was. And I asked, and Lieutenant Albert complied. Let's get the right answer for this jury. Let's go look at the right answer. Let's not have the wrong answer, even if it only means a foot or a foot and a half of difference in terms of the tide. One witness says the tide shifted 3 feet. They presented evidence. Mr. Albert said it was about 1.75 feet above the normal mean of the water. All evidence is clear. It was high tide when this crash occurred. Ed, can we put on the screen D Delta? And you may recall I used the tape measure to establish that at high tide, 6 feet plus 3 feet is 9 feet at the top of the marker. I believe this is what the state says is the size of the marker. And if on the piling, this is the marker. Green, of course. Okay? And so you have your experience of having gone to see the boat, where the gunnel of that boat would be relative to the piling that I represent right now. And whether someone sitting on that gunnel might obscure the operator's view. Of course, should the operator, under normal circumstances, if he recognizes that his view is obscured, request that the passengers make room? Of course. But that's not reckless and conscious and flagrant and gross to overlook that problem. Now, marker 13A, not 13, prosecutor said 13, let's be clear, there's a 13 and a 13A. Let's put 13A. The testimony is that 13A is 5 feet taller. Lieutenant Albert said it was 5 feet taller. So I brought a tape measure. Three and a half inches. So 13A, the bottom of 13A, the bottom, would be 5 feet above my head. Okay? The top would be 3 feet tall. Okay? So 13A, that would be 5 plus 3, 8 feet. That's the top of 13A. Okay? And you can see that quite clearly in Exhibit I, which is a photograph that we showed you through Lieutenant Albert. Hold that right there. Hold it. Southbound, going back to Ocean Reef. There's 13A. There's 13. So it's 12, 13, 13A, 14. They're staggered over there. And if we can zoom in, you can see at this angle, there's 15 obscured behind 13A. And I asked Lieutenant Albert, and again, I didn't ask him how much he gets paid. I trusted that he'd be honest. Wouldn't matter how much he's getting paid. He's a law enforcement officer. I believe he would do the job, and he did. Please tell the jury if there was a point in time where those two markers, if the operator was looking through the channel where the GPS track showed, was there a point in time where marker 13A would obscure marker 15? And he said yes. And I think we have that in the Lieutenant Albert F. Next one. No, you wouldn't go too far down. Up. There you go. Keep. Eye. Obscure right there. Is that it? I'll find it in a second. We'll find it in a second for you. But the testimony was that at 34 seconds to go, that's the number that he testified, Lieutenant Albert. 34 seconds to go, those pilings line up with the operator's view. Now let me be clear. George Pino has no memory of this, no reliable memory of the crash. And I'm not saying to you that in fact, that at that precise moment in time, with 34 seconds to go, George Pino looked up, was looking down the channel, and they were obscured. Although the prosecutor brought out from Albert that at 34 seconds to go, it might be that green marker 15 is not even visible because it's still too far away for the human eye to see it. Don't have a reliable memory of what happened, but nor does the state. Nor does the state. But one thing we know for certain, the tape measure doesn't lie. The GPS doesn't lie, the tape measure doesn't lie. And we know for certain that marker 15, for reasons that the Coast Guard will have to explain at some other time, why would they make a marker 5 feet lower than all the other ones in the channel? We're not blaming the Coast Guard, because I'm waiting for the prosecutor to stand up and say the defense is blaming the Coast Guard. I'm just bringing you the facts. And that's a fact. And so when we saw the recreation of Lieutenant Thompson mimicking what the Robalo might have done, it did not give you a visual of what the operator of the boat of the Robalo was seeing in the last 9 seconds. Because the camera that Lieutenant Thompson was using was in front of the windshield, not at the position where the operator stands. This exercise of crime scene investigation, you heard from Manuel Palmares. He confirmed that marker 15 is the shortest marker in the Cutter Band channel. He talked about the green paint, that the green transfer onto the Robalo. to finish out the loop. The accident happens at 6:37:19. Someone will tell me if I got that. Excuse me, 6:37:28. 6:37:28. At 6:36:54, so let's do our math together, that's 6 seconds before 7 p.m. I'm sorry, 6 seconds before 6:37, plus another 28 seconds. 28 plus 6 is 34. 34 seconds from this point until elision. 34 seconds. And that's where 13A obscures 15. If the boat is here, the operator's looking down the channel, the operator's view would be obscured. And I'm going to repeat myself one more time. Don't know if that's what happened, but it's not our burden to prove to you what happened. Our burden is nothing. Our burden is to appear here in court and answer, we're here. But we don't have to present any evidence. But we take the step to bring you all of the evidence for you to consider. If the operator is looking down the channel, could the operator have counted 2 green on the left, 2 red on the right, continues for 10, 15, 20 seconds, and when the operator passes marker 13A, having counted 2 green on the left, 2 red on the right, thought, I just passed the last marker, the last green marker in Cutter Bank Channel, veers towards the left to go to Angelfish Creek, and says, hi honey, what are you doing? I'm sending a text message. 8 seconds later, there's a collision. Don't know, but the state has to explain to you why what happened there was more than just, as they've said so far, mere inattention. That was Palmares. Bengal Dahl, Detective Miami-Dade Sheriff's Office. He was the one, I think he was photographing, he was the drone guy. He said that the operation by Lieutenant Thompson in recreating what the Robalo did was, quote, safe so long as you don't hit the channel marker. Well, we all agree. What George Pino was doing was safe, provided he sees the marker in time to avoid it. And let me make one other thing clear. Green marker 15 is visible. To use the word as we understand it, it's visible. It's 3 by 3. If you're looking straight at it, you're going to see it. If it's like the pothole down the street, it doesn't, you can see it, but it's just not registering, you could miss it, even though you could see it. When I say miss it, I mean you could not recognize or not register that it's there. And if you do that, it means you're human. It happens to us as humans. It doesn't turn us into criminals. And Bengal Dahl, he testified that the exercise of having Lieutenant Thompson copy the path that the Robalo took, showed a steady course. No beeping, no hot dogging, no thrill seeking. A slight turn at any of the last several seconds would have avoided the marker. He was asked a question as the vessel, talking now about Lieutenant Thompson, recreation of the Robalo. As the vessel was traveling in the path at that speed in these conditions, did it appear to be operating unsafely? Answer, no. The only thing that would create a problem is hitting the marker. Answer, correct. This is, as I tried to explain earlier, this is the car that's not driving on I-95 like a lunatic, but gets into an accident because, for example, the car forgot to hit its blinker, took a pass, change lanes, gets hit, and people get hurt. Did they violate a rule of the road? Yeah, they didn't turn on their blinker. Did somebody get really badly hurt or worse? Yeah, but no one's going to jail for that. And now we come to the 6'8" Lieutenant Albert. And I think he gave you the answer he thought was the cause of this accident. His opinion. He, the police, testified that the passengers seated in the bow area could have obscured the operator's view. Meaning that George Pino was driving along with a swivel, looking, and that the girl sitting in the front obscured his view or perhaps distracted him, and he didn't take note of what would otherwise be a visible marker, and he struck the marker. And you may recall I counted down with him, 9, 8, 7, 6, 5, 4. During any of those 5 seconds, if George Pino had taken note of the marker, he could have avoided by a quick turn of the wheel, not even that quick, just a turn. But if he didn't notice it until 3, 2, 1, it would be too late. And if it's because the seating arrangement made his view of the marker less than ideal, it wasn't because George Pino was trying to be in reckless disregard for people's safety, gross, flagrant, or anything of the sort. A few additional witnesses, the civil attorneys who testified, prosecutor emphasizes that the insurance company's appointed lawyer for the Pinos, Mr. Mescalado, following insurance company protocol, files a petition for limitation of liability to consolidate all the cases into federal court. A lawyer doing his job, with a client urging him, I want to make sure everybody gets compensated. And the insurance company's lawyer saying, this is how we do business with the insurance company, and George Pino deferring to his lawyer. And still, everything gets resolved civilly. He holds himself accountable. He resolves the issue of compensating people that are terribly injured and worse for their injuries and their pain and their suffering. And yes, George Pino maintained the same memory of the event a year later that he had the day of the event. That's the nature of a confabulated memory. It's the only memory George Pino has of the event. And he shares it with his lawyer. And his lawyer shares it with opposing counsel. And the case gets resolved regardless. Has nothing to do with the decision you have to make about whether George Pino was acting grossly and flagrantly and recklessly. If I could just have a second.
Vessels upon its waters to follow navigational rules. However, a violation of these rules
He was culpably do that with the intent of crashing into the market. Or they'll say he was culpably negligent, that he should have known. But as we would
Oh my gosh, it just moved us ahead. And I got to kind of remember where we stopped off. I know you do not want to hear anything that he has to say twice. I know. Before anybody get excited. They moved us ahead. They probably the jury is probably deliberating right about now. Let's see here. Oh, look at that face. Ugh. Did y'all see this face already? That must be the daughter. I'll screenshot that. Oh no. You said you done went to Walmart and checked out and bought the whole grocery store and he's still talking? Heck yeah. I just don't want to repeat no parts that we seen, but shoot, it just moves me. It don't give me no warning, no nothing. So let's do from here.
And reckless. If I could just have a second. Early on, we talked about the two crimes that George Pino is accused of and which he'll render a verdict on. One of those crimes is manslaughter. And manslaughter, while the elements, they sound alike, manslaughter has two different ways to have the state allege it and prove it. One is, can you put up the manslaughter? Thank you. Thank you. Manslaughter. A, intentionally committed an act that caused the death. I submit to you that intentionally committing an act, the state hasn't proved by any stretch that he intentionally went into that marker which caused the death. It was not George's intent. Then there's the question of culpable negligence that we talked about throughout this presentation. I just want to make sure that we don't miss that there are two different theories that the state is presenting to you. Did George intentionally commit an act that was not merely negligent, that caused the death? Well, the prosecutor told you if he intended to hit the marker, we all agree. Going 47 miles an hour, George Pino intended to crash into the marker, guilty. But that's not what he intended. We all know that. And so the state resorts to this culpable negligence theory. Or maybe the state will say to you his intentional act was turning the steering wheel. And that's the act you should look at. That he intentionally turned the steering wheel, which put him on, as they'll say, a collision course. But you certainly know he did not do that with the intent of crashing into the marker. Or they'll say to you it's culpably negligent, that he should have known. But as we've addressed with you already, can't be the product of mere negligence. If that's what happened, if George Pino was negligent, he is not guilty of manslaughter. Because turning the wheel, unless you hit the marker, nothing bad happens to anyone. The speed is safe. It's steady driving. The conditions are excellent. We all know what caused the tragedy here is striking the marker. And speaking of the marker, can we show the jury Exhibit J and K? You may recall some discussion about the GPS and how George's SIMRAD device, the GPS device, when magnified, the red line purporting to be the path of George's boat, and when it's magnified, for whatever reason, I think Lieutenant Albert tried to explain that the markers are on a different map than the track. It actually shows that George's boat never actually alighted with the marker when you magnify it. Now again, I am not telling you that George Pino was driving, staring at his GPS, and thought that he was going to avoid the marker. But what you know from the track is that as George was going in the channel, which is basically southwest, at some point in time, he starts turning to the left, port, because he's headed to Angelfish Creek. And we know that marker 15 is to his left, to his port side, until he actually strikes it, and he strikes it with his starboard side. So he actually shifts left. Now, he could leave the channel at any time. There's no rule that he has to stay in the channel. There are no other boats in the channel. He can, typically you stay to the right, but if there's no other boats, you can take the middle of the channel. If you want to go in the shallow water, you can just make a right turn or a left turn and go to the shallow water. But I think what this tells you is that George Pino, it did not register that he had one more green marker to go, because he's doing the veer to the left that he would have ordinarily done when he gets to marker 15. And it may just be, for the reasons we've discussed before, that the state thinks he was inattentive, he should have known he had one more marker to clear before he was out of the channel. Whatever it is, it was not an intentional act to hit the marker. He did not intend to come close to the marker. He intended to take these girls back to Ocean Reef. And so now I'm going to ask you to try to get into George Pino's mind. Because ultimately, our criminal laws are here to punish people who act with a level of depravity, of gross and flagrant behavior, that there's some malice. And when I say malice, I don't mean like malice.
Judge, Your Honor, that's not our state law.
I'll just call it
I'm sorry, Counsel. The court will instruct you in the law, ladies and gentlemen. Go ahead, Counsel.
some level of, I think maybe the better word is depravity, a degree of recklessness that leads you as jurors to believe that George Pino was acting consciously, intentionally against the interests of the passengers on board. And you know that when you see it, the pickup truck that puts people in the back of the pickup in a place where no one is supposed to be seated. I suppose you could use the example of putting a bunch of kids on the hood of a car in front of the windshield, and a car is not made to have people travel on the hood or in the back of the pickup truck. And if you saw someone doing 47 miles an hour with a bunch of young kids in a pickup truck on the interstate, you'd say, whoa, that guy's out of his mind. You'd know it when you see it. But when George Pino left the sandbar that day, it's for you to decide, was he taking extraordinary risk in traveling back to Ocean Reef, back to where he came from? Because failing to exercise ordinary care, if he made a mistake as the operator, that doesn't result in a criminal conviction. There may be civil liability, but not a criminal conviction. And so, what was in George Pino's mind? What was in his heart? And I think it's clear because you know what the occasion was. He was there that day to celebrate a wonderful time a beautiful time in his life, surrounded by the people he loved. Was he really trying to be a show-off, to be the cool dad, really? By driving his boat back to Ocean Reef while the girls, they probably didn't even notice George Pino. As they told you, they're in their own world. It's not like he had a bunch of race car drivers who wanted to see just how fast a boat could go through an obstacle course. This was a dad with his wife by his side, his daughter seated in the bow area. Perhaps daydreaming, perhaps appreciating a beautiful moment in his life, perhaps thinking about how lucky he is. Does he really think that in his heart and in his mind, he was saying, F it, I'll just floor it and I'll throw caution to the wind? Does anyone really believe that? George Pino? And of course, a bad thing happened. A tragedy happened. And a lot of pain has come from this. And I know that there are a lot of people watching, people that have been affected by this.
Objection, it's not relevant.
You heard the testimony of people who came to this court and told you the families that were affected by this. And they're watching. And they deserve sympathy. They deserve an open heart from all of us. Their lives have been changed forever. And it's a hard thing to do, to be a juror in a case where those kinds of feelings have been part of this trial every single day. At the same time, the reason why we have jury trials is because we count on people who have no connection to the injuries, no connection to the feelings, who can try to apply the law dispassionately, even if you have sympathy. It's okay, the two things can coexist. We can all be sympathetic. We can all feel the pain that this event has caused so many people. You can feel it. We all felt it when we had to look at some of these photographs, watch some of these videos, and how they've been played over and over again. None of which has anything to do with the cause of the crash, only the injuries that followed from the crash. And the prosecutor has spent an enormous amount of time showing you just how painful this crash was. It doesn't answer the question of what was in George Pino's mind and in his heart, which bleeds for the families that have been affected by him operating that boat. No matter what your verdict is, he will have to live with that for the rest of his life. People he grew to love, people that walked in his wedding, children who spent time in his home. And so in rendering your verdict, yes, we can all be sympathetic, we can all feel the pain. The law says, though, that when you analyze the evidence, you need to do it dispassionately. And I submit to you, if you do it dispassionately, you'll know that there was only love and kindness in that man's heart. And that never once in his mind did it occur to him.
Objection, counsel testifying.
There is no evidence, none, that ever once in his mind he thought that he was putting anybody's life in jeopardy. Not his own, not his wife's, not his daughter's, not Lucy's, not Kathy's, not any of the other girls on that boat. And if anybody at that sandbar had thought that George Pino was going to put the lives of those girls in danger, they would have said something, but they knew who George Pino was and is. He may not be the coolest athlete, but he's also not a criminal. You should find him not guilty.
All right, thank you, counsel. Ladies and gentlemen, we're going to take a little stretch break. Please put your notebooks inside your envelopes. You can leave them on your chair. And please do not discuss the matter. Thank you.
All right.
As I told you at the beginning of this trial and jury selection.
All right, ladies and gentlemen, we will now proceed with the rebuttal voice. Thank you.
Good afternoon again. I know it's been a long day. I'm going to try to confine my remarks simply to responding to some of the things that the defense team has put forward. First and foremost, I want to say this. It is not the mission of prosecutors like Mr. Borst and myself to label anyone as a criminal. My job, as I told you at the beginning of this trial and jury selection, is to present evidence. And I am organized, and so is Mr. Borst. And that's why we were able to introduce into evidence more than 100 items for your consideration. Videos, photographs, body-worn camera recordings, written documents, court pleadings, copies of receipts from the point at Ocean Reef Club. We're organized because we have a mission, which is to present the evidence for you, the jury, to consider. It is not our job to ask you to make your consideration out of sympathy. And I will tell you in no uncertain terms, if Mr. Borst and I did not prove the charges of vessel homicide and/or manslaughter, and you decide to find him guilty because you feel bad for this girl, you will tarnish her memory. Because your verdict would be a miscarriage of justice were you to convict this defendant if the evidence does not support the conviction. But likewise, I'm not coming to you asking you, oh, poor Lucy, he's a monster. No, I'm not doing that because that's not my job. That's not professional. But at the end of defense counsel's summation to you all, he was basically asking you to have sympathy for this defendant. Look, we're all human, but your verdict cannot be based on sympathy for anyone in this case. It has to be based on the facts. Counsel saying, oh, maybe he was thinking about how lucky he is or how much he loved his wife or whatever. You know what that's called? That's called speculation. The judge is going to give you an instruction about what reasonable doubt is. It's not an imaginary, forced, or speculative doubt. What was in the defendant's heart and mind when he smashed into that channel marker is irrelevant. What's relevant for your consideration is what is the evidence. So let's talk about that evidence. The defense takes one word inattentive, and says that's what I base my whole case on. And that's just not true, and I'll tell you why. This case is based on so many failures on this defendant to operate in a safe, prudent, and reasonable way that any one thing by itself, well, you can make a mistake. But when you heap mistake after mistake after mistake on him, when he was the one at the helm, when he was the one calling the shots, where they go, how fast they go, then we know. First off, we've got him with 12 teenagers, 10 of whom are on the bow of that vessel, leading to at least 1,000 extra pounds, which if you remember Mr. Albert's testimony, remember he had that bright green boat, and he showed you how the extra weight on the bow of the vessel is going to make it harder for it to operate on a plane, so you're going to be going faster, and the faster you go and the more weight you have on the boat, guess what? The harder it is to navigate it. So that's another problem that we have. This vessel becomes less responsive because of the weight and the speed. Let's take another factor into account. The fact that he had a bunch of teenagers who'd been drinking the alcohol that he provided. How does that factor into recklessness? It factors in because you now are responsible for the lives of minors, but not minors that are operating at the peak of clarity, minors that have consumed alcohol, and some of them a lot of alcohol. You're responsible for the people on your boat. So you darn well be driving carefully to get them safely back to the party you're waiting for. But what else? The fact that he'd been drinking too. That's a factor. I'm not here to prove that he was BUI. I'm here to tell you that this is yet another knock against the safe operation of a vessel. The fact that none of these girls were wearing life jackets, the fact that he wasn't wearing a kill switch, did those cause him to crash into that channel marker? No. But if you're being a safe and prudent operator of a vessel, if you are taking your responsibility seriously, then if you know that they've been out drinking, if you know you've been drinking, it's reasonably foreseeable that maybe everybody's not at their top of their game. Maybe it's likely that people could maybe not have their best judgment. So you know what you do when you're a safe and prudent operator of a vessel? You tell the kids, put on life jackets. And you wear a kill switch. Because if something were to happen, and those engines keep spinning, which we know they did from that last track mark that Mr. Albert showed us. Remember the little curve? You see all those little track marks. Those engines were still going, thank God. Thank God nobody got chopped, okay? But that's another factor for you to consider. Here's another one. We know from the specifications of that boat, he was going full throttle. Just because that Robalo is rated that it could go as fast as 55 miles an hour doesn't mean that it's safe. I think I've seen a lot of cars that have speedometers that go past 100 miles per hour. Just because you can do something doesn't mean that it's safe and prudent to do it. Imagine operating a car. A driver puts the pedal to the metal and makes that car go as fast as it can. That's what this defendant did with a boat full of kids. What else makes this reckless? What else makes this criminally negligent? He knows exactly what channel marker 15 is. First off, he'd gone past it earlier that very day to get up to the sandbar. But beyond that, you saw the track marks that were left from his boat time and time again of him going from Ocean Reef to that sandbar. He knows that that channel marker is there. But he pays no attention. What else takes us into the recklessness? There's no reason for him to have crashed into that channel marker There was no wind, the seas were calm, and it's daylight. What else makes him reckless? What else makes him criminally negligent? He's on the wrong side of the channel. Did that in and of itself cause the crash? No, but when you think about the rules of the road say we operate on the right-hand side of the channel. If he's operating on the wrong side of the channel, especially during a Labor Day weekend when you have more vessel traffic, if there is another boat, had there actually been a family boat, right? Where's that boat gonna go? It can't go outside the channel if it's big, because it's gonna run aground on the shallow waters of Biscayne Bay. That's a hazard. So all of these things, not just the 9 seconds, but I want to really emphasize the defense talks to you about the fact that, oh, maybe it was just a couple of seconds. No, it's not just a couple of seconds. I can't stress this enough. This is how long he was headlong toward that channel marker that he knew was there when he'd been drinking with a boat full of kids, with a vessel that's overloaded with weight for that speed, when he's going full throttle and on the wrong side of the channel. This is how long he is checked out. Ready, set, go. That's a long time. Nine seconds. That's more than enough time to check your GPS screen. That's more than enough time to see if any other boats are coming by. That's more than enough time to even, if you want to glance at your wife's cell phone. That's a long time to be heading straight into a steel pole with a gigantic day-glow green sign on the top of it that you know is there. So it's not just, a few seconds of inattention. It's everything together. You have to consider all the factors that were at play, all the things that had to happen for him to wind up hitting that channel marker. And, as to the defense attorney's point that, but if he only would have just gone a little more in this direction or this direction, he wouldn't have hit the channel marker. Okay, let's think about this. Let's think about somebody that goes skydiving, maybe has a parachute on. Splat, right on the ground. Well, gosh, if only he would have pulled the ripcord, he'd be okay. Like, that's the kind of argument that you're giving. That doesn't make sense, and the law makes sense. The law can't be such that a person can be that inattentive, can be that checked out, zoned out, spaced out, whatever you want to call it, that you are utterly unaware of your circumstances. You are not taking into account the safety of your own passengers. The law can't abide by that. It's not about labeling anybody a criminal or a bad guy or a good guy. It's about evaluating the conduct and applying the law. And along those lines, I just want to say that to give you an idea of just how much all of these different factors really count in a case like this, I have this rope. And if you look at rope, which ironically for a nautical case, I guess, but if you look at rope, there are many little individual strands, none of which by itself would be strong enough to hold on to an anchor or that one boat can tie up to another, okay? But what happens when you take all the little strands of the rope and you start intertwining them and you weave them together, those little strands, when you put them all together, become very strong. And that's why the evidence in this case is very strong for the fact that he was operating his vessel recklessly, and that because of all those other factors, which I already covered when I spoke with you initially, not just reckless. Reckless is the baseline for this conduct. More than reckless. Culpable negligence, manslaughter. To the extent that defense counsel says he never wanted his daughter or his wife or those kids to get hurt, of course. Who would say otherwise? If I had the proof that he deliberately tried to kill somebody, the charges would be different. But just because you don't have an evil heart or you don't have an evil intention, it doesn't mean that you are immune from the laws of this state. If you, even without an evil heart, engage in a course of conduct that is clearly this dangerous and that clearly could have such devastating consequences, then you're properly charged with vessel homicide and manslaughter. Now, I had a feeling that we were going to hear from the defense things like, there's no requirement to wear life jackets. There's no speed limit. There's no requirement for a kill switch. There's no proof beyond a reasonable doubt that the defendant was impaired by alcohol. There's no proof that expired flares don't work. Of course, none of those things individually caused this crash. But again, with the rope scenario, these are just more factors to take into account. Not wearing the kill switch, not having the kids in a life jacket, that you have been consuming alcohol, that you are going as fast as you can. And to say that there's no speed limit on the water, that's not true. There is. The speed limit is set by navigational rule number 5, which Mr. Albert told you about. Pardon me, 6. You have to go at a safe speed for the conditions. It's not the same as being on the land, obviously. We have 55-mile-an-hour speed limits, sometimes 60 miles an hour speed limits. Through school zones, we have 15 miles per hour speed limits. But on the water, the rules can't be rigid the way they are on land because the water is a whole different environment. This was a flagrant foul, if we're talking NBA. The defense attorney says, oh, the prosecutor, she tells you all this about Lucy's injuries. And I do. But not really so much to tug at your heartstrings, because I'm telling you, it would not be a lawful verdict for you to find the defendant guilty just because you feel sad about Lucy or the injuries she had, or you feel sad for her family. That's not what we're here for you to do. But you understanding those injuries was a necessary component of this case. Because you know what? You don't go so fast. Your boat doesn't smash into the channel marker so hard. Your boat doesn't wind up being basically severed from stem to stern. Your boat doesn't start taking on water to the point where it flips upside down and traps a young woman who had her head bashed. You heard from Dr. Garavan, our Irish medical examiner. He talked to you about the fact that the injuries that she had are consistent with her hitting her head and then her head jerking back, which is why she had that deep bruising in the back part of her neck. And that could cause her to become unconscious. And her now being trapped under that boat, which, like I said earlier, basically became her gravesite. Her being trapped is what caused her to die. So that's why you needed to understand those injuries, because you know what? You slow down, your boat doesn't hit so hard. Your passengers don't get conked in the head to the point where they're rendered unconscious. You don't wind up unconscious. If you just slow down, operate your vessel safely. He didn't want to do that day. He clearly knew how to. People trusted him. People trusted that he would take their children out to that sandbar and be safe. So he knew how to operate safely. He simply chose not to. The defense attorney talked about alcohol. Oh, everybody was drinking. Okay, well, first off, just because everybody's doing it, A, doesn't make it right. And B, the only people who testified from the boat about whether or not the defendant looked impaired were themselves drinking alcohol. We had the defendant's wife takes the stand, and, she acknowledged, yeah, she was drinking Chambord and Prosecco from one of those Yeti tumblers. She says, yes, I was drinking, but what was kind of funny is that in court, she said 1 or 2 drinks. But in her interrogatory, if you remember when I read that to you, and you'll be able to look at it for yourself, in her interrogatory, she said she had 2 drinks. How come she all of a sudden now, oh, I only had 1 or 2? But on her interrogatory, she had 2. And maybe 1 drink here or there, but come on. Prosecco and Chambord. She remembered, but she wanted to undercut how much alcohol she had consumed. So we think that this woman is in a state to really make a good judgment about whether or not her husband should be piloting that boat. Do we think that Cammie, with the 10, alcoholic drinks in her system, is a good judge of that? Caro had been drinking? All these girls have been drinking. They were not the ones to be in a position to make an assessment if he's capable of operating a boat. They're there as kids to have fun at a birthday party. Don't divest your own responsibility onto underage kids that you gave alcohol to. That's what the defense has tried to do regarding that alcohol. It's not a DUI case, but the alcohol can't be ignored. Here's the hatch. You all saw this boat. Here's what it looked like when the police opened it up. And then the police lined up a lot of those alcohol containers that they found from inside. Am I saying that this defendant drank all of them? No. Can I say that the girls drank all of this alcohol? No. But this photograph, states 109 in evidence, tells a story about how prevalent alcohol use was on that afternoon. And because it was so prevalent, he had a duty to be careful. Not just be beyond negligence, but he was so far beyond the pale. It does cross into recklessness, and it does cross into criminal negligence. At least if the defendant was maybe buzzed or impaired by alcohol, at least there would be some explanation for why he crashed into that channel marker that's so clearly visible. Had too much to drink. At least there's an explanation. You could understand why. Not that you think that it's a good thing, but it's understandable. But let's suppose he did not feel any effects of alcohol whatsoever. Does that then not make him even more reckless and more culpably negligent? Because then what the heck are you doing, buddy? Why do you not see that which is right in front of you? I can almost understand it if it was alcohol. Again, it's not good, not appropriate. But to crash into it if you really were stone cold sober, that's almost worse.
Objection, burden shifting.
The navigational rules are the warning to all voters. Violating navigational rules all by themselves will not land you in a case like this. But when you violate so many navigational rules, you're on the wrong side of the channel, you're going too fast. Nobody says that you have to have somebody serving as a lookout, but man, if you don't have anybody serving as a lookout, you'd better be looking out yourself. And he didn't do that. That's like so fundamental. The navigational rules of taking steps to avoid the risk of a collision. Him traveling on that wrong side of the channel, with channel marker 15,
Okay, there we got it. He got the rosemary, he got the beads, y'all. Y'all see him clutching them? He got the rosary beads. Uh-oh. Oh, man. What am I going to do with this guy? He should not be allowed to have this type of stuff. Y'all see this? Man.
clearly visible to him.
And he praying. Y'all see him mouthing off stuff? What he doing? Praying? Oh. If y'all don't come get Georgie, that's what I'm saying. This is too much. Oh my goodness. Like, this is just too much. He's shaking his head. He's mouthing stuff. He's doing a lot of different things right here. And he clutching on to the beads, the rosary beads. Like, okay, no, sir. So now they supposed to look at him. They supposed to look at him thinking, first, he religious, right? So that means that, you know, most people sometimes when they hear religious, they like that they know can't do anything wrong. Second, he's sitting up there clutching them. Third, he's sitting up there praying and mouthing or doing something. This is crazy. I can't believe this is happening. They letting George do too much up in this courtroom.
Even abide by that rule. And then, of course, the rule number 8, avoid a collision. He had plenty of time to avoid that collision. He didn't. The defense attorney said to you that it's not fair to his client to say, oh, you shouldn't have had all those girls seated in those seats on the bow of the boat. You know what wasn't fair? It wasn't fair to Lucy and those other girls to operate that boat that fast with that many girls there. Sure, they could sit there, but if you've got that many kids sitting up at the front of your boat, slow down. Don't tell me that it's not fair to him. It wasn't fair to any of those girls, all of whose lives he endangered. This is footage from a drone that did in fact follow a vessel. It's following the same path that this defendant operated. Here you can see channel marker 14. Let's a little bit. Channel marker 14, channel marker 15. This is the boat that Detective Dow and his partner, Sergeant Kopp, were on operating the drone. The drone is following the FWC vessel that's trying to recreate as close as possible the path that this defendant took on that day. Closer and closer to number 15. Closer and closer. And it's only because Lieutenant Thompson is a damn good pilot of a vessel that he did not collide with that channel marker. And so to the point where the defense attorney said, oh, if somebody was on a drone and watching Mr. Pino operating his vessel, would they want to stop him and say, what are you doing? Yes. Of course they would, because they'd say, what are you doing? Why are you heading right to that channel marker? The drone tells you. Here we are, right by channel marker 15. Here comes the FWC vessel. Look at that course. Anyone who saw that vessel coming from that distance would say, what are you doing? Are you crazy? Why are you risking your life and the lives of these kids? How can you do that? So let's talk a little bit about these injuries that the defendant had. It's funny how he's just fine to crawl up onto David Rodriguez's boat, but he's so damaged that FWC, oh wait, no, FWC didn't life flight him away. They didn't take him in a helicopter away. They had fast boats that could get him to the mainland. They had the means to take him if he was seriously injured, like they did for other passengers. Not him. He was treated, you have body-worn camera footage from Lieutenant Thompson on the Elliott Key Harbor. You'll see that he's got his head bandaged, yeah, his head's glued. And yeah, you gotta seal the wound. Stitches don't make a lot of sense for heads, so we use staples. But he needed staples, whether it's 3, 7, but the only medical care that he told Dr. Barrett that he had was therapy and some psych meds. And I don't take anything away from somebody seeking mental health care if they've been through a difficult scenario. But that is not the same as somebody that has a head injury so bad that somehow it causes them to create false memories without the intent to deceive. And then when we think about that evidence, false memories without the intent to deceive, let's go back again one more time. And the defense says, oh, like I'm some kind of horrible person because I have the audacity to challenge what a medical doctor says in this courtroom. I challenged her because the testimony that she gave is not credible, but you're the judges of who's credible. But she literally took the stand and she said she based her finding that he had amnesia just on these 4 things. that he didn't remember who sat behind him, that he said his engines were 225 horsepower, that he couldn't remember exactly what happened post-impact, and that at first he said it was Nati, then he said it was Lucy. That's it? You get paid 30 grand for that? She didn't even say that he did confabulate, right? She just said it could have happened. But again, reasonable doubt is not a speculative doubt. What evidence do you have that this is really signs of amnesia? First off, we already talked about the fact that even she testified. Oh, whether or not he could remember exactly who was behind him, she's like, well, that makes sense that he would not remember who was behind him. She said, yeah, you know, after a traumatic event, maybe you don't remember exactly what happened. We already talked about the fact that it would make sense if maybe he was confused about which girl he saved initially, because he wasn't the one that brought that child to the rescue boat. He just ducked under his boat after being told to do so and recovered the body, but then passed it off to someone else. And I don't mean to refer to Lucy as an idiot, but that's what he did. So the one thing that we're left with, the reason why we believe that this defendant gave that whole story about a phantom boat is because he thought that he might have engines of only, 225 horsepower? That's not reasonable. I'm not here to bully anybody, but I'm also not here to allow you to not think about whether or not the expert witness that's called is giving you testimony that you should feel comfortable relying on. The witnesses that I brought to you, trust me, I'm not going over all of them, but I think it's worth kind of looking at in totality. Look at the officers who were called. Bobby Bruto, Sergeant Delgado, Ben Dow, the drone operator, Detective John Dalton, who's both been a Marine Patrol officer and a vehicular homicide or traffic homicide investigator. You heard from Lieutenant Morris and Lieutenant Thompson. Did any single one of them get caught up in some kind of sense that what they were saying to you, they didn't know what they were talking about? That they had some ulterior motive behind doing this? How about the passengers? Cammy, Caro, Claudia, Natalia. They all come here and say, we were there for a good time. We've known the Pinos for a long time. We felt like we were safe, but, geez, most of these girls are sitting facing backwards. They have no position to know whether or not George Pino is operating his boat safely. What about the Good Samaritans that you heard from? Hillary Candela, who knows everybody involved, called Conti Poit's dad to say, hey, I'm out here on the water. I think there's been an accident. Hamlet Rodriguez, who takes Lucy's body and gets it to the Good Samaritan vessel. David Rodriguez, maybe a little bit of a character, because, I don't know a lot of people who come across a man that's stranded with his boat and take time to photograph it, but he did, okay. I thought it was interesting that the defense showed you that 6-second video that he had of the defendant, but I was like, oh, you got a picture of him too? Well, come on down here. Let's show that picture to the jurors, and I think that when we zoomed in, you could see the defendant not saving anybody, just hanging onto his boat. You heard from a couple of doctors. Dr. Garabin, the medical examiner, and you heard from Dr. Barrett. I'll let you judge who's credible. We heard from some lawyers, Brent Reitman, who was one of the attorneys that represented the Puig family in their lawsuit. Didn't ask him a whole lot, just wanted to make sure you understood what interrogatories were. The defense, I called Mr. Mescalado just to confirm, yes, this is a normal part of the discovery process in a civil case. That was it. I just had him read the interrogatories. But, when the defense called him back, he starts talking about how Mr. Pino wanted to make everybody whole and all this other stuff. Who cares, right? But it did become relevant that he did try to limit his liability once he makes a statement like that. It did become relevant that he tried to get counts of the lawsuit dismissed. He made it relevant, not me. All I wanted was the interrogatories to come in. But at least he did admit that in answering an interrogatory, it's perfectly fine to say, I don't know. I didn't see the crash. Did Cecilia Pino do that? Talk about Mr. Albert. You know, knows his stuff down cold. Not impeached with a single thing. His expertise in GPS data extraction, interpretation, unchallenged. That GPS data that you got is irrefuted. You talk about Andy Fernandez taking the stand at the beginning of this trial and as the very last witness, who despite having lost his firstborn child, kept it together and answered questions. Can you imagine cross-examining that man and like trying to get a oops, gotcha? Because, oh, you weren't planning on going there? Well, don't you remember that client sent a text to you about meeting up at the sandbar a week before? Yeah, and at that time I thought maybe I would. But on that day, I was tired from playing golf and I didn't really need to go all the way out to the sandbar and then come all the way back because I had my plans to go to a football game with my dad. That's the gotcha of the father who lost his 17-year-old child because of the actions of a man that had been his friend? Rudy Queen took the stand. You know, the injuries to his daughter are not really the issue here, but to the extent that something was made by Mr. Mescalado, the defendant's former lawyer, about, oh, the Queens didn't settle, you deserve to know at least that she's not the same now as she was before this crash.
All right, Councilman, so.
Thank you, Judge. Last 2 points I want to make. The defense in this case had no burden of proof. The burden of proof fell solely on Mr. Borst and me. Throughout this trial, we've presented you with what I would submit are very compelling witnesses. We've presented you scientific facts, data that would substantiate a guilty verdict for both vessel homicide, for being reckless, as well as for manslaughter. And so when you go back to the jury room, I'm going to suggest, but it's totally up to you, that you may wish to first look at count 2 of the information, vessel homicide, and that you can make a finding that because the defendant was reckless, even if nobody else was on his boat but his wife, just the direction of travel put him on a collision course, that the verdict would certainly be guilty. But then I would suggest, but it's your call to make, that you then consider all these other factors that were at play on that day. These factors didn't have to be there for a vessel homicide conviction, but because they are there, I'm also asking you to return a verdict of guilty as to the manslaughter charge. Because he did do an intentional act by deciding how fast to go and what direction to travel, and that caused Lucy's death. And because the way that he operated that vessel was culpably negligent. And the very last thing I want to say to you is not me speaking to you, it's you watching what happened in this case. not reckless, if that's not culpably negligent, what is? Thank you for your time and attention to this trial, ladies and gentlemen.
Thank you. May I see counsel and courtroom sidebar? Please, everyone, please stay quiet. Members of the jury, you have now heard all of the evidence in this case, as well as the final arguments of the lawyers for each side. It is now my duty to instruct you on the rules of law that you must follow and apply to arrive at a verdict. You as jurors are the judges of the facts, but determining what actually happened in this case, that is, in reaching your decision as to the facts. It is your sworn duty to follow the law I am now going to define for you. You must follow all of my instructions as a whole. You have no right or authority to disregard or give special attention to any one instruction, or to question the wisdom or correctness of any rule of law I state to you. Accordingly, you must not substitute your own notion or opinion as to what the law is or should be. It is your duty to apply the law as I give it to you. Ladies and gentlemen, you will have a written copy of the instructions to take and to use in the jury room with you during your deliberations. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. George Pino, the defendant in this case, has been accused of the crimes of manslaughter and vessel homicide. Manslaughter and vessel homicide are unlawful. However, a killing that was excusable homicide or that was committed by the justifiable use of deadly force is lawful. If you find Lucy Fernandez was killed by George Pino, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or vessel homicide, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. The use of deadly force to kill a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon George Pino, or to commit a felony in or upon any dwelling house in which George Pino was at the time of the killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. The killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances. One, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or three, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Luciana Cristina Fernandez is dead. 2, George I. Pino, A, intentionally committed an act or acts that caused the death of Luciana Cristina Fernandez, and or B, the death of Luciana Cristina Fernandez was caused by the culpable negligence of George I. Pino. Every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm. That violation is negligence. George I. Pino cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I had previously instructed. To convict of manslaughter, it is not necessary for the state to prove that George I. Pino had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or a grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of another. Culpable negligence is consciously doing an act or following a course of conduct that George I. Pino knew or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of vessel homicide, the state must prove the following two elements beyond a reasonable doubt. 1, George I. Pino operated a vessel in a reckless manner likely to cause the death of or great bodily harm to another person. 2, his reckless operation of a vessel caused the death of Luciana Cristina Fernandez. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. The state does not have to prove George I. Pino intended to harm or injure anyone. However, the reckless operation of a vessel requires the state to prove more than a failure to use ordinary care. A reckless manner means in willful or wanton disregard for the safety of persons or property. Willful means intentional, knowing, and purposeful. Wanton means with a conscious and intentional indifference to consequences and with the knowledge that damage is likely to be done to persons or property. Vessel is synonymous with boat and includes every description of watercraft, barge, and airboat, other than a seaplane on the water, used or capable of being used as a means of transportation on water. Operate means to be in charge of, in command of, or in actual physical control of a vessel upon the waters of this state, to exercise control over or to have responsibility for a vessel's navigation or safety while the vessel is underway upon the waters of this state, or to control or steer a vessel being towed by another vessel upon the waters of this state. In the state of Florida, the law requires operators of vessels upon its waters to follow navigational rules. However, a violation of these rules, individually or cumulatively, is not sufficient by itself to constitute culpable negligence or recklessness. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything to the crimes charged, as I have previously explained to you. Whenever the words reasonable doubt are used, we must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. During the trial, you viewed and listened to certain audio and video recordings. Some of these audio and video recordings have been edited to eliminate irrelevant portions that would not aid to your understanding of the case. The fact that the recordings were edited should not concern you in any way and must not impact the way you view and or listen to and consider this evidence. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. The Constitution requires the state to prove its accusations against the defendant, George Pino. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement or statements claimed to have been made by the defendant outside of court have been introduced into evidence. Such a statement or statements should be considered with caution and be weighed with great care to make certain it or they were freely and voluntarily made. If you conclude the defendant made the statement or statements, you must also determine from the evidence whether the defendant's statement or statements were freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to: 1, whether when the defendant made the statement or statements, he had been threatened to get him to make the statement or statements, and 2, whether anyone had promised him anything to get him to make the statement or statements. If you conclude the defendant made the out-of-court statement or statements, but it was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find George Pino guilty as charged or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. You will also have the verdict forms with you in the jury room to use to document your verdict. First, verdict form in the Circuit Court of the 11th Judicial Circuit in for Miami-Dade County, Florida, State of Florida versus George Pino. Verdict: we, the jury, find, you can't probably see it from there, but we, the jury, find as follows: as to count 1 of the information, manslaughter of Lucy Fernandez, the defendant is, and the first line, guilty as charged in the information. The second line, not guilty. You check only one. So say we all on this blank day of blank 2026. The foreperson is to sign and date and also print their name and date on the verdict form. Second verdict form. Again, in the Circuit Court of the Circuit in Miami-Dade County, Florida. State of Florida versus George Pino, verdict. We, the jury, find as follows as to count 2 of the information: vessel homicide of Luciana Cristina Fernandez. The defendant is, the first line, guilty as charged in the information. The second line, not guilty. You check only one. So sitting all on this blank date of blank 2026, the foreperson is to sign and date, and also then on the next line, print the name and date. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. In just a few moments, you're going to be led into the jury room by the court specialist. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. Any notes you have taken during the trial may be taken to the jury room for use during your discussions. Your notes are simply an aid to your own memory, and neither your notes nor those of any other jurors are binding or conclusive. Your notes are not a substitute for your own memory or that of other jurors. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court specialist. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of devices into the jury room. Kindly leave those devices on your seats. Actually, Renee is going to collect those from you, and he will keep those and guard those for you while you deliberate. If you need to communicate with me, send a note through the ballot, court specialist. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. You will have a laptop to use to view digital evidence. You will also have a device to use with the computer to be able to view the other digital evidence introduced during the trial. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, actually coming to 250 years, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Are there any objections to the manner in which the instructions are read to the jury?
Judge, yes, as we approach.
Sure.
Man, I know my court reporter lady, she is tired of having to get up and drag this thing with her over to take when they had these sidebars. Now, he had an objection to something in regards to the way she read that.
Ladies and gentlemen, I am going to ask please if Miss juror number 29, initials MD, please stay in the courtroom. Juror number 35, initials AM, please stay in the courtroom. Juror number 48, initials CL, please stay in the courtroom. And juror number 63, initials NL, please stay in the courtroom. The rest of you, please take your notepads and please enter into the jury room to begin your deliberations.
All rise.
Everyone be seated, thank you. Well, ladies and gentlemen, you might feel extremely disappointed at this time that I would advise you that you have been selected as alternate jurors in this case. The disappointment may come from the fact that 4 of you have sacrificed over 3 weeks, I don't know how many days, but a various number of days, to serve as jurors in this case. The sacrifices really were extraordinary. This was not a 1 or 2 day trial. We engaged in an extensively long jury selection process. And then the trial proceedings, again, over the last few weeks. It took so much for each and every one of you to place this, your service on a jury in this community, as your priority. It was forced upon you, really. You didn't volunteer for this work. It says so much about each and every one of you as citizens in our community and in our country as to how you value your responsibilities and this branch of government. If we don't have citizens like yourselves to make these sacrifices, it'd be chaos. This branch of government must remain strong, and does remain strong, because of citizens like yourselves. And again, this was just not an ordinary sacrifice because of the length of time that was involved. And not only did it impose on your time and disrupt your lives, but I'm certain it disrupted the lives of those closest to you. who had to pick up the slack and to take on responsibilities that you normally undertook. But you were here to do this work. And the disappointment may come because you are not engaging in the last part of the work, which is the deliberative process. It's really just a token of appreciation, what I have for each one of you. I'm going to step down and give to each one of you this certificate of appreciation, again, which might feel a little insulting because of the sacrifices that you've made to do the work. But please understand that you are no less important to us and for what has been done and the work that we all have done than any of the other jurors. We can't tell people that they're selected as alternate jurors because there is the risk that they may not give the case the same attention and consideration as that they would normally give. So we don't tell you. We keep it a secret. So with this, let me also tell you, once I discharge you from your service, you have no further obligations to this court. You can keep your privacy as you will. You are not required to speak with anyone at all. You become like every other citizen. We are a public courtroom. You're welcome to stay. You're welcome to go home. But you no longer have any obligations or commitment to court or to this case. And again, you can maintain your privacy, even as an alternate juror, unless this court orders you, which I will not, to speak with anyone. It is your prerogative to do so. Okay? So let me come down and give you each a certificate, and then I will give you each discharge and farewell. Miss M.D. Thank you very much. You're welcome. Miss A.M. Miss N.L. Thank you. And C.L. Thank you so much. So you can gather your personal belongings if you would, and you can leave your notepads. I want to put them out and they will collect them, and they will be destroyed. And again, your prerogative to speak to whoever you wish to speak to or no one at all. And again, I want to thank you on behalf of myself, on behalf of all the parties, for the extraordinary work that you have done. We are proud of you. We are proud of you as citizens in this community for the sacrifices that you have made. And thank you. You are now discharged.
Stay still, please.
All right, you can all be seated, and let me give you some further instruction with regard to jury deliberation. This courtroom is cleared and locked. No one is committed in this courtroom other than, if necessary, court staff, but certainly just the court specialists, my God. So, this includes the attorneys as well. But before the attorneys leave, we need to look at and go through all of the evidence to make sure that what is to go back to the jury is separated from what is not to go back to the jury. So I'm going to let all the lawyers start to gather to do that work. As for everyone else, again, if there is a question, we will notify the attorney. If there is a verdict, we will notify the attorneys. In addition, we don't disrupt the jury in their deliberations, and we will work to a reasonable time. We're not going to work into the wee hours of the night. Just to let you all know that. It's not my intention to do that. The jurors don't know. We don't tell them. So we're just going to let them work. And again, everyone, the courtroom is cleared completely. We don't allow anyone in the courtroom during the deliberations. Renee may wind up locking the door even. So you should take your personal items and belongings with you. And I think we'll probably work until somewhere close to 8 o'clock and see where we are at that point. If the jury has not reached a verdict at that point, I'll explain the process to you all now. We will reconvene. I will instruct the jury that they're going home. They're not sequestered. And they return the next day. We don't meet. They are brought right into the jury room to continue with the deliberations. The parties do not gather at all. So this courtroom will remain locked. If you do have to come back tomorrow, it will remain locked. It will not be open for anyone other than Renee and the jurors to continue in their work. Okay, so just to give you a preview, and we don't know, but that's kind of our plan for today. Thank you very much, ladies and gentlemen.
Orders from the defense to answer 3.
So I guess I want to say that they have been deliberating for maybe about an hour. maybe about an hour, maybe a little bit over an hour. Morel, the Leslie B is another content creator. She does true crime in a minute. So a lot of her streams are like evening time, like I guess is a way to say it. So like right now she is currently she's streaming the openings and the closings, the closing. So I was going to join the panel and watch closing statements, like a dual stream. But I gotta figure out I don't know how to do it. I'm about to see if I know how to do it to keep our chat open. So while we on verdict watch, because y'all know typically during verdict watch we'll go back and watch closing statements or something to that effect. But instead of us doing it over here, I was just gonna join a panel, and that way, we'll join with her, and then that way we can stream to both platforms and kind of like talk about the trial and the closing arguments at the same time. No, Martina, no. So while we are waiting for verdict watch, that way we wouldn't have to be at, there's a different way of doing it. But let me see. You said we could just meet in Discord and you just pop in if there's a verdict. Well, yeah, you don't have to I mean, it's totally up to you if you guys want to go over there. I did tell Leslie I'm gonna come over there and hang out with her and her crew today to discuss the Pino thing, you know, the debacle of a mess. So let's see here. I just don't know how to do it really. But yeah, they've been out an hour. I don't even know how long she gonna let them deliberate. Let me see something. Wait a minute, I'm just trying to see something. You say you don't have Discord? Oh no, I know the feeling. I know when I first started using Discord, man, I was like, I do not like this. I do not want to learn this. I don't want any parts of this at all. And I don't know what happened, but somehow I ended up on there and we started watching movies and stuff and watching different like little episodes, and I kind of just like fell in love with it. But I will be the first to tell you that no, it was not the thing for me. Wait a minute, hold on. I'm gonna play some music real quick. Let me go see if I can get my I need to figure out how to do this. I don't know how to do this. So let me see. I can probably figure it out, but I'm gonna have to get my phone so I can Google on it. Hold on one second.
Sun comes up and somebody's already there, posting memes and opinions nobody has to share. The trials on the screen, but that's not why we stay. We're solving all the world's problems in the chat all day. Somebody's making hot dogs, somebody's cracking claws, somebody's citing statutes they learned from watching Lost. The witness takes the stand, but we're off somewhere else, discussing snacks, bad tattoos, and making fools of ourselves. Hot dogs and white claws every hour of the day. The trial's just background noise while the chat drifts away. One eye on the testimony, one eye on the fun. Started watching for the case, but stayed for everyone. Hot dogs and white claws, that's the family we chose. Showing up with bad advice and inside jokes nobody knows. The lawyer keep on talking, but that's not why we're here. We're gathering around the internet with friends we've grown to cheer. Judge says overruled. Somebody posts a gift. 20 people miss the ruling while they're shooting all the shit. The evidence is serious. The vibes are mostly not. Half the room is paying attention. Half forgot the plot. Morning crew and night crew, somehow all the same. Different clocks and time zones. Everybody knows your name. The stream could end tomorrow and we'd probably still hang out, arguing over nonsense till the lights all flickered out. Hot dogs and white claws every trial's just background noise while the chat drifts away. One eye on the testimony, one eye on the fun. Started watching for the case, but stayed for everyone. The verdict comes and goes, another case rolls by, another 100 conversations underneath the sky. Hot dogs and white claws and friends we never saw somehow built a little hometown through a screen and a law. When the live stream flickers on and Sweet Pea takes a stand, Lynn is already there, coffee in hand. She settles in for the long trials, the twists and the turns, with a loyal heart and steady eyes that never miss a word. She's a constant in the courtroom, a familiar shining face, always ready for the arguments, the tension and the pace. And when the evidence is messy or the stories sound untrue, she leans forward just a little. Lynn knows what to do, 'cause Lynn thinks everyone is guilty, every suspect, every tale. Melody Fair is guilty, she says without fail, but Dr. Rachel shakes her head. Sure, the son is to blame, still Lynn stands firm, her verdict stays the same. Oh, she brings the truth with a calm, steady light, and her presence is a comfort on every trial night. She listens with devotion through each objection and plea, through the cross-exams and pauses. She's where she needs to be, in the sea of courtroom chaos where tempers sometimes flare. Lynn remains unshaken, a voice of reason there. And though the chat may chatter and the theories may divide, Lynn's perspective never wavers. She speaks with honest pride. She keeps the room grounded when emotions run loose, a quiet force reminding us she's here to find the truth. Yes, Lynn thinks everyone is guilty, that's just her way. From the first opening statement to the end of the day, Dr. Rachel can argue the son's the one at fault, but Lynn won't budge. She's rendered her final thought. We appreciate her always for her loyalty and her proof, 'cause the chat shines a little brighter when Lynn brings the truth. Two back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in chat. If Sweet Pea goes live, yeah, she's right on that.
pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the feed. We the California's rolling deep on line. Four corners, one crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. Four names, one flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Point her to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah. Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
Junkie, 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 junkie.
Susie, Shamrock,
Girl,
Shamrock.
we the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, we stay in the mix. Four names, one flame, can't remix this.
Okay, I don't know. We gonna try it. So, I created us a verdict watch room. I did put a redirect for us to go over to that verdict watch room. I am going to place this here for the link just in case it does not take you over to the verdict watch room. And then I am going to join over with Leslie, and I think I'm gonna be able to hit this multi-screen stream kind of like too, and it should let me stream so the chat can kind of stay together, but I don't know. we shall see how this works. Not quite sure at this point in time. It's my first time trying this one. Because usually I just go on the platform and then just, you know, we all just usually crash the party. But it's not that case here. So just trying out something different. Okay. But if I do lose you guys, that's where I would be at with true crime in a minute. So you can always go over there, but I'll be able to see y'all over there. So if worst case scenario, when I come over there to the StreamYard to the Verdict Watch, I'll let y'all know if it's not working. But we'll kind of go from there. Okay. Yeah, well, right now I've just got us going to our own little Verdict Watch room, which is fine because we almost at 4 hours here. So once we get over 4 hours, things get wonky with StreamYard. So we're good there. So that's a good thing for us. So we will go ahead and go over to, I'll go over there, set everything up, and then I'll bring you guys in. That way you should be able to just see me and her on one platform, and then y'all be chatting and y'all chatting. They'll be in their chat. That the only thing, and I guess, I don't know if we'll be able to show each chat on stream. I don't know. I don't know how that goes. So right now, I just got y'all going to our Verdict Watch room, so y'all can just go right. Oh, wait. I'm putting the wrong thing in there. Dang it. Let me get the link. I did that wrong. Let me take this out. Wait a minute. Delete that comment. So let me get the link to our Verdict Watch room. I'm like having brain farts now because I don't know. I don't know. Let me go here. Let me get the link to our Verdict Watch room. It should drop you right off over there, y'all. So just in case, it should drop you right off over there. But in case it don't, here's the link for the room. Okay, guys, I'm gonna end this stream. I'll see you over in the Verdict Watch room, and then we're gonna link up with Leslie. All right, cool. I'll see you then. Peace.